Within hours, multiple attorneys filed motions to withdraw, pointing to irreconcilable conflicts with their client as the nation's highest legal unraveling ever seen for a modern American political figure. It's difficult to grasp that we're witnessing a former president's defense collapse in real time. Trump now stands on the brink of looming trial dates with his legal representation in tatters, the Supreme Court unwilling to step in, and lawyers choosing to walk away rather than continue defending him. According to one insider, the atmosphere at Mar-a-Lago descended into total disorder, with Trump lashing out at remaining staff while desperately dialing potential replacements. This goes far beyond a routine courtroom setback. What's unfolding looks increasingly like a constitutional crisis, where the leading contender of a major political party could be forced to defend himself in federal court because no qualified attorney is willing to take the risk. And trust me, the implications of this double catastrophe are going to reshape American politics in ways we haven't seen since Watergate. Let me fill you in on what's been happening. To understand the magnitude of this disaster, you need to appreciate how unusual it is for the Supreme Court to issue emergency rulings and how devastating attorney withdrawals are at this stage of litigation. These two events happening simultaneously represent the worst possible scenario for any criminal defendant, let alone a former president seeking to return to power. The Supreme Court ruling came down just after 10 a.m. Eastern Time. Trump's legal team had filed an emergency application seeking to stay all trial court proceedings while appeals on various legal issues worked their way through the system. They argued that forcing a former president to stand trial while constitutional questions remained unresolved would cause irreparable harm to the institution of the presidency. And here's where it gets even worse. The court didn't simply reject the request. It issued a short, unsigned order that legal scholars are already describing as a flat-out rejection of Trump's entire legal approach. The ruling, published immediately on the court's website and echoed across every major news outlet, states that the application raises no significant legal issue deserving of the court's involvement, and that the applicant failed to show any realistic chance of prevailing on appeal. In plain terms, the justices reviewed the arguments and found them nowhere near persuasive. The order then went further, delivering what analysts are calling a rare and pointed reprimand. It emphasized that the proper functioning of the justice system requires trial courts to keep their schedules moving, and that delay requests built on hypothetical appellate outcomes do not meet the threshold for emergency relief. In other words, stop stalling and show up for trial. CNN's Supreme Court correspondent noted just how unusual the timing was. Trump's application had been on file for less than 48 hours. In most emergency matters, the court takes days or even weeks, often asking the opposing side to weigh in. This time, the justices ruled almost immediately, without requesting any response from prosecutors. That alone sends a powerful message. The court viewed the filing as so lacking in merit that it didn't even justify the standard process. But this is the moment when the situation crossed from damaging into outright disastrous. Less than 3 hours after the Supreme Court's ruling, 3 of Trump's remaining lawyers moved to exit his cases. The first withdrawal came from a senior attorney in the classified documents matter. In the filing obtained by the Washington Post, the lawyer pointed to a complete breakdown in the attorney-client relationship, saying continued representation was no longer possible. The motion referenced professional and ethical duties that could not be met under the current conditions without detailing what those conditions involved. The second withdrawal involved an attorney working on January 6th related cases. This filing was notably sharper, stating that recent events made it impossible for counsel to continue advancing arguments demanded by the client. Legal analysts were quick to observe that this phrasing strongly implies Trump was pushing for legal positions the attorney believed crossed ethical lines or lacked any legitimate basis. The third withdrawal, submitted shortly before 2 p.m., came from the lawyer overseeing Trump's broader legal strategy across multiple proceedings. This filing raised the most serious red flag, aware of information, creating a conflict of interest that could not be waived, leaving immediate withdrawal as the only option. According to legal ethics experts who spoke with MSNBC, that language is a red flag. When attorneys cite conflicts of interest discovered during representation, it often means they have learned something that makes them potential witnesses against their client, or that they've been implicated in potential crimes themselves. Now, this isn't the first time Trump has burned through attorneys, but the scale and timing of today's collapse is unprecedented. Just think about the revolving door of lawyers who have represented Trump over the years. When Trump's legal battles began in the aftermath of January 6th, he initially assembled what looked like a powerhouse defense: seasoned lawyers from elite firms, former federal prosecutors, and experts in constitutional law. But over time, that roster has steadily thinned. One after another, attorneys have walked away. Some pointed to deep strategic conflicts. Others cited Trump's refusal to accept legal counsel. And in several cases, lawyers found themselves confronting potential legal risk stemming from actions taken at Trump's insistence. The pattern has been unmistakable. Lawyers sign on, quickly realize that representing Trump means advancing arguments they consider professionally indefensible, and ultimately exit. Many leave with their reputations bruised and their finances strained by unpaid legal fees. Tim Parlatore, a well-regarded former federal prosecutor, stepped aside earlier this year, blaming internal chaos and interference from unelected figures inside Trump's inner circle. Joe Tacopina, who defended Trump in the E. Jean Carroll defamation case, departed following conflicts over both legal strategy and compensation. Christopher Kise, a former Florida Solicitor General who joined the team with considerable publicity, has since seen his influence wane amid repeated clashes with Trump over how the cases should be handled. Then there are the attorneys who didn't just leave, but became witnesses against Trump. Evan Corcoran's notes were turned over to prosecutors under the crime-fraud exception. Jenna Ellis pleaded guilty in Georgia and agreed to cooperate. Sidney Powell took a similar deal. These aren't obscure figures. They were central to Trump's legal defense, and now they're central to the prosecution's case. This pattern exposes a deeper truth about defending Trump. It isn't merely challenging, it's a professional hazard. Lawyers who take on his cases often find themselves pushed toward arguments that test ethical limits. Asked to promote legal theories judges dismiss as baseless, and placed uncomfortably close to conduct that could carry serious legal consequences of its own. And today, 3 more attorneys reached the breaking point. So what exactly set off this sudden wave of departures? And why did it unfold at the exact same moment the Supreme Court shut the door on Trump's last-ditch legal maneuver? Sources familiar with the thinking of Trump's lawyers, speaking to multiple outlets, say the Supreme Court's rejection was the breaking point for attorneys who had been growing increasingly uneasy. For weeks, they had warned Trump that his strategy to delay proceedings was failing, that courts would not indefinitely push back trials, and that he needed to start preparing for the reality of facing juries. According to these insiders, Trump's response only escalated tensions. He demanded more aggressive tactics, more baseless motions, and more attacks on judges and prosecutors. He pressed his lawyers to pursue claims they believed could lead to sanctions, to make public statements they considered potentially defamatory, and to follow strategies they feared would backfire spectacularly. When the Supreme Court's denial arrived, it effectively ended the delay strategy once and for all. There were no more courts to turn to, no further procedural maneuvers left to try. The trials were set to proceed, ready or not. At that moment, attorneys who had been holding on in hopes of achieving delays realized their position was untenable. They could continue representing a client who refused to take their advice, making arguments they considered frivolous, facing potential sanctions and reputational damage, all while not getting paid reliably, or they could withdraw. They withdrew. But this development raises even deeper concerns. The withdrawal motion, citing an unwaivable conflict of interest, points to something far more serious than a mere strategic dispute. Legal ethics experts, speaking to CBS News, note that such language usually indicates the attorney has encountered information placing them in an untenable position. Maybe the lawyer discovered that Trump misled them about key facts, making continued representation require advancing false claims. Maybe they became aware of ongoing criminal activity, they would be obligated to report. Or perhaps evidence surfaced showing they were being used unknowingly to facilitate obstruction, turning them into potential witnesses. Whatever the exact cause, the conflict language sends a clear message. This attorney didn't just lose confidence in Trump's defense. They concluded that ethically and legally, they cannot continue under any circumstances. Now, with trial dates looming, Trump finds himself in a nightmare, a crumbling legal team, and no obvious path forward. According to court schedules that remain in place, despite today's Supreme Court ruling, Trump is set to face his first federal trial in just a few weeks. Jury selection is imminent, witness lists have been exchanged, the prosecution is fully prepared, and Trump's defense team is rapidly unraveling. Under typical circumstances, a defendant whose attorneys withdraw shortly before trial would request a continuance to allow new counsel time to prepare. Judges usually grant such requests to ensure adequate representation, but Trump has already exhausted much of that goodwill. Judge Chutkan has made it clear she will not tolerate delay tactics, and even Judge Cannon, who has generally been favorable to Trump, has expressed frustration with his legal team's behavior. Prosecutors are likely to argue that Trump orchestrated this crisis intentionally, whether by pressuring attorneys with unreasonable demands or failing to compensate them, creating a pretext for delay. If the judges determine that the withdrawals are tactical rather than genuine, they could deny continuances, forcing Trump to proceed with whatever legal representation he can scramble together. In the most extreme scenario, Trump could be forced to represent himself, a prospect that terrifies even his most loyal supporters. According to former federal prosecutors who spoke with MSNBC, pro-se representation, representing yourself, is almost always disastrous in complex federal cases. You don't know the rules of evidence, you don't understand procedure, you can't control your emotions when confronted with damaging evidence, you make objections incorrectly or fail to make them at all, you alienate jurors with your demeanor. Conviction becomes nearly inevitable. And then Trump managed to make the situation even more disastrous, though by now that's hardly shocking. Within hours of the Supreme Court ruling and the mass attorney withdrawals, Trump unleashed a flurry of posts on Truth Social. He labeled the Supreme Court corrupt and compromised, including the 3 justices he himself appointed. He denounced his departing lawyers as weak and disloyal, suggesting they were part of a coordinated plot against him. He threatened lawsuits for malpractice and breach of contract and insisted he never truly needed lawyers, claiming he could represent himself if forced. Legal experts were quick to call this approach reckless. When the goal is to recruit competent attorneys, publicly attacking former counsel and threatening legal action against them is essentially the worst strategy imaginable. Every skilled lawyer in the country is now witnessing Trump vilify his own team and asking themselves why they would ever put themselves in the same position. The Wall Street Journal reports that at least 5 attorneys recently approached about joining Trump's defense declined after observing how he treated previous counsel. With each public attack, the pool of available qualified lawyers continues to shrink. This sets up a vicious cycle. Trump needs attorneys, but his treatment of them drives competent lawyers away. That leaves him with weaker options. Weaker lawyers produce poorer outcomes. Poorer outcomes fuel Trump's anger, which he directs at his attorneys, and the cycle starts all over again. The Supreme Court ruling's implications reach far beyond the immediate trial schedule. Legal analysts tell multiple outlets that the court's language effectively shuts down several strategies Trump had been counting on. Its statement that no substantial legal question exists signals a lack of interest in revisiting immunity claims or other constitutional arguments he has raised. The note that he failed to show a likelihood of success suggests the justices see his pending appeals as meritless. This is critical because Trump's entire legal playbook hinged on the Supreme Court eventually stepping in. For months, attorneys had been telling supporters and perhaps convincing themselves that even if lower courts ruled against him, the high court would provide a safety net. That hope has now been extinguished. The conservative supermajority Trump worked to create, the justices he took credit for appointing, have now definitively abandoned him. They're not going to stop his trials. They're not going to throw out his convictions if juries find him guilty. They're not going to invent constitutional doctrines to protect him from accountability. Trump spent years claiming the court would protect him. He was wrong. And now he faces trials without that safety net. This whole scenario is sending shockwaves through Republican politics because party leaders are finally confronting the reality they've avoided for months. According to reporting from Politico, Republican strategists held emergency calls throughout the afternoon trying to assess the political damage. The consensus was bleak. Trump is now facing trials he cannot delay with attorneys who have abandoned him, while the Supreme Court has made clear it won't rescue him. Some strategists are now entertaining what just weeks ago would have seemed unthinkable: whether the party needs a contingency plan if Trump becomes legally unable to continue his campaign. What if he's incarcerated before the convention? What if he's convicted but continues to appeal while running? What if no competent attorney will take his cases in courts, force him to represent himself? These are no longer abstract hypotheticals. They are immediate, practical problems the party must confront. Republican donors are taking notice as well. The Wall Street Journal reports that several major contributors who had been funding Trump's legal defense have contacted the campaign to pause contributions until the legal situation is clarified. They want to know who is representing Trump, what the strategy is, and whether there's any viable path to avoiding conviction. Without satisfactory answers, they are holding their support. The timing couldn't be worse for Trump politically. With primary voting approaching, he needs to project strength, competence, and inevitability. Instead, he is projecting chaos, desperation, and looming legal peril. Trump's opponents, particularly Nikki Haley and Ron DeSantis, are treading carefully, testing how to take advantage of the situation without seeming opportunistic. Republican insiders speaking with CNN report that both campaigns have prepared statements and ad strategies to roll out if Trump's legal troubles deepen. They are balancing a fine line, voicing concern about legal overreach while subtly signaling that the chaos surrounding Trump could make him unelectable. So what does this double catastrophe mean for the near term? First and foremost, Trump needs new attorneys immediately. With trials just weeks away, he requires seasoned federal criminal defense lawyers who can step into highly complex cases on short notice. That is already a very limited pool. Factor in Trump's history of not paying bills, ignoring legal advice, and publicly attacking former lawyers, and the pool of willing, competent attorneys shrinks to near zero. According to legal recruiters who spoke with the New York Times, Trump's team has been desperately reaching out to attorneys since the withdrawals were announced. So far, the response has been uniformly negative. One attorney reportedly responded, "There isn't enough money in the world." Another said, "I have a career to think about." Second, judges must decide how to handle the withdrawal motions. They can accept the withdrawals and potentially delay trials to allow new counsel to prepare. They can reject the withdrawals and order attorneys to continue representing Trump, or they can accept the withdrawals but refuse to delay, forcing Trump to proceed with minimal representation. Based on the patterns we've seen from these judges, they're unlikely to reward what appears to be a manufactured crisis. Expect tough questioning about whether Trump caused the breakdown in attorney relationships. Expect orders requiring Trump to provide evidence he's diligently seeking new counsel. Expect minimal delays, if any. Third, Trump faces the genuine possibility of representing himself. If he cannot find counsel and judges refuse to delay, he would appear in court as a pro se defendant. He would have to question witnesses, make objections, deliver opening and closing statements, and navigate complex federal procedure without legal training. This would be a spectacle unlike anything in American history. A former president, potentially the nominee of a major party, stumbling through a criminal trial without knowing basic courtroom rules. The footage would be devastating. The outcome would almost certainly be conviction.